Hello, everyone, and welcome to Happy Tuesday on America's Some Assembly Required. So today we have a little bit of work to do ourselves. We're going to be talking about the court clerk today. Unfortunately, Anna is not able to join us because she's off she's been working all night actually on international issues and business right now that are of much more importance. And so I'm going to try today to address the court clerk and their duties and some of their functions, and to try to help answer some of your questions regarding court clerk. So we'll get started. I expect the podcast not to be maybe quite as long as if Anna was on. So we'll try to get it done and get it into your learning. And next week, hopefully when Anna can rejoin us, then we'll be able to take and maybe ask a few more questions or continue on with the topic itself. So bear with us. As you can see, I'm in a little different location. I've started a little winter travel. So if you notice the difference in the background, it's because I am traveling. So you'll hear a little bit of different noises and sounds in the background as well. So I apologize, but I'm doing the best I can, right? So today like I said, we're going to talk about our court clerk. And the jural pillar really doesn't put the court clerk as important as they really are. I'm going to tell you, I'm going to crack a few jokes along the way, but I love our court clerk. He is hardworking. He's very detailed. And that gives you just a couple of good insights into what the court clerk needs to do. He actually deals with all the paperwork of the court. He starts the whole process and he keeps track of everything. I always tease about the court clerk. They actually do run the court. If you don't believe me, go ask one. Even in the de facto, the court clerks run the show. They keep the justices on track. They keep the paperwork flowing. They're almost like the conductor on the orchestra of the court. They conduct all the things back and forth that keep our courts aligned and running in the way they want. So the court clerk is going to start with being highly organized. They have to know your court process. They have to be able to understand all of the forms and know what is the appropriate form in the appropriate step. They're going to make sure that those forms are filled out correctly and completely. And then they also have the extra duty of using the court seal in their receipt of those forms or the filing of those forms. They're going to make sure that they're interfacing with the IT department, with your IT, because eventually your court will have its own separate, almost database of court cases that will be on the public sides of your websites, so that you can access those former court records and filings, as well as see the progression of a court case. And many of us are not quite to that point yet, where we have either that type of connectivity or we have our courts up to where we need those types of things. So realize that the court clerk has a huge learning job to do. He's going to be participating in your Jural Assembly to try to get your forms together, make sure that every step of your court has the appropriate forms, and that he or she understand what those forms actually mean. He's going to make sure that once those forms are filed, that they get to the appropriate people, to the claimant, to the accused, to the justice, to the juries. And so he's orchestrating a lot of pieces, a lot of moving parts. And so high organization is something you're looking for in that court clerk. Now, the court clerk has some very specific abilities. He can take a look at beginning paperwork and tell you, sorry, you don't have the right forms, or there's not enough here to file a case, okay? Or you have not been through the appropriate steps in our jural process to be able to be in this step. So, and he's going to do that in honor. So don't think that that can be something that he can just decide, oh, sorry, you're not coming into our court, right? He has a certain degree of honor that he has to carry and responsibility and duty to that court position. He's an officer, right? And so he is he's really bound to make sure that there is good due process involved with having cases come and go through our court system. So the court clerk has to know what our common law is. He knows to know what his public law is, and he's especially has to know what our court process is. Okay, so as in our process, we have basically a self-governance phase on Ohio. Then there's what we call an impartial review committee. Some people call that arbitration. And then it goes into, if not settled there, it goes into our living court. And each one of those phases are a phase of which evidence and or facts or testimony is gathered along the way. And all of that big snowball of things continues to roll through our court system until it gets into the jury process. So the court clerk is going to be watching all of these forms. He's going to make sure that they're autographed appropriately, that all the steps have been followed along the way, and that everything is ready and set up for court. And he actually is the one that is, in many ways, preparing the justice who's sitting on the bench, or the justice of the peace in the county, in the case of a county court. He's going to make sure, or she's going to make sure that justice has everything before them. They can see that all of those things are in order. The justice will have time to look that over. And that it also goes to the jury, so that the jury has time to also look over some of the information as it enters into the court. So as we've talked before, our justice is really there more like a referee, but he's also watching over certain aspects of the due process in the court setup, and that's based on those court documents that your court clerk is bringing through. Obviously, if there's not enough filed, if it's just a dispute where the court clerk can basically say, go back to self-governance or go back to arbitration. And you're going to have to develop more either witnesses or evidence, or you're going to have proof of claim. All of those things have to be involved in terms of the court clerk. So he does have a little bit of discretion in terms of the information that flows into and through the court. When it gets into a living court, and you have a jury there in the living court, most of that paperwork, the evidence, the testimony, those things have already been listened to, at least in arbitration. Now, unless new facts or new evidence or new witnesses come forward, then basically that court clerk's going to move that paperwork on in to your living court. Your jury is going to have the ability to look at that paperwork and then listen to both the claimant and the accused as to the importance of that paperwork. Jury's going to be able to ask questions then based on that. They're going to be able to ask for more investigation or more evidence. They may ask for certain pieces within that. But that all depends on what is brought through that court clerk and comes into the living court and into the living jury. So let's just take, for instance, if that court clerk has moved that evidence in, and the jury begins to say, oh, wait a minute here, we're seeing some evidence of criminality, then all of that paperwork is preserved. And the justice needs to see that in terms of what it is. And if need be, it gets passed on then into a grand jury. So all of our phases are meant to build and build and build. And hopefully we can stop any of our disputes or our controversies, as it's called, and be able to stop those in the self-governance phase and be able to negotiate with each other on an a man-to-man or man-to-woman, woman-to-woman basis, right? Because we need to settle our differences as best we can. It moves on into arbitration. And sometimes the self-governance phase also involves the ombudsman. And that ombudsman paperwork can be called for and submitted through our court clerks in as either evidence or witness or, whatever that might be. So, so it's one of those things that realize that court clerk has lots of moving parts, and he or she's going to have to keep track of and move those through our court system as appropriate. All of that documentation, if there's a evidence of criminality, then flows into our next phases of court, which is our criminal court. And that goes into grand jury. And if our grand jury finds that there's enough within evidence within and criminality within the claims, they can actually go into presentment or indictment, as they call it in the other jurisdiction, and presentment, and then it goes into a trial by jury. So, so the court clerk keeps all of that information organized. It keeps it moving through our court, and it comes out to the very end. Court clerk is going to file all of that information. They're going to take that. It's going to be put up for electronic preservation, archived basically, and any of the other, paperwork that's generated along the way, either by the jury, by the justice, all of that is going to move through along with that glut of paperwork. So now you can see why I said that man or woman has to be highly organized. And they can come into court and they can bring, they can bring certain things into that. And as things are filed, they can continue to, present that evidence, or, if there's something filed within the court that changes a case, a new case can be open. So that court clerk can actually, he's assigning numbers. And in your court systems, you're going to be tasked with sitting down and looking at all of your paperwork and trying to decide how you're going to number your cases. That's once you determine how to do it, that's what the court clerk then does, is he'll put that together, whether that's a state, a county number, a bullion day number, court case number so-and-so on that day. Those numbers will travel through, and they're almost coded in a way so that later on the court clerk, the justice, the bondsman, the court recorder, they can all tell exactly what that case is and what that coding means in terms of how those case numbers are generated. So court clerk's going to be doing that. And then court clerk also is going to be responsible for keeping the filings of all of that, both physical and electronic. So as we, move through and you get the court is interfacing, there's one other thing that comes into play with the court clerk's job, and that comes into the criminal side. If there's a criminal case, and let's say, unfortunately, you might have a dirty sheriff, and you have a dirty sheriff who has a dirty coroner, and you can't seem to get any type of issues reviewed or added into the court via the normal processes of going to the sheriff or going to the coroner, then the court clerk can act and put that case or register that case, not register, but slate that case for the grand jury. He can review that evidence. He can review that claim, and he can place that on the docket for a grand jury and go around essentially the sheriff and the coroner. And in that case, then there's probably going to be some type of an investigation opened by your marshal at arms or your court oversight committee into the activities of the sheriff and the coroner. So there's always a check and balance in our systems. We're always trying to make sure that we're building it in so that we're always held to the highest integrity of what goes on within our peacekeeping units, our courts, especially. Our true freedoms are freedom for money and freedom for justice. And so we're always going to be guarding that with a check and a balance on either side. Coroner can also bring those court cases into a grand jury, can do a coroner's inquest. If the coroner is acting like a sheriff on a county that does not have an active sheriff, an elected sheriff, then the state coroner can also bring those into a grand jury and work cooperatively with the court clerk. Court clerk needs to work with everybody. He's working and he can send you on to, for example, he may suggest that you contact your litigation committee for assistance in getting your processes together, making sure you've got all your paperwork and all of those things as you open your courts. Okay. So, and he's going to make sure that all the way through, he's constantly the check and the balance for the justice to make sure that the justice has done the right paperwork, that he's signed the right orders, that he's put in the right kinds of documentation to the case. Okay. So he's more or less a supervisor over the court in many ways. He's supervising the court recorder. He actually supervises the bondsmen. He supervises all of those processes that go on within our court. Okay. So court clerk is a huge job. And the court clerk is going to eventually have deputy clerks. They're going to have, he's going to have plenty of backup and administration. So he's got a lot of things that he's going to be supervising and taking care of. And he's got to make sure that it's 100% correct and in the correct order. Okay. So it is really up to the court clerk a lot of times. If there's something that he observes in court that's going sort of sideways, maybe somebody stepped out of line or there's a process out of line, it's his duty to call that time out with the justice and have the justice kind of time out the court or, be able to suggest maybe a continuance until an issue is actually worked through within the court administration. So, the court clerk is always there to help, and he or she is always there, but their main job is keeping everybody on the same page, to keep them organized and, be the check and balance within our court system. So, again, I can't stress it more. Your court clerks need to be intimately involved in the production of paperwork on the assemblies, on your Jural Assembly. They need to be intimately involved in and communication with your justices. They need to be in communication with your jury pool because they're going to be helping guide that jury pool in the selection of jury. Okay. So the court, and he's going to be picking up anything that may be detrimental to the due process of your court system. So it's really great to be able to work through all of the documentation with your court clerk and make sure that you've got all your parts and pieces. Court clerk is also going to check and make sure he has the final seal. He carries the court seal. And so he's going, the justice might stamp something from his point, but it's not filed until that court clerk actually puts the court seal, the court clerk seal on things. So considerable amount of work for someone. In an active case, you can bet that the work, that the filing work, the paperwork is tremendous. Okay. So even though everyone's very anxious to get their courts up and running, having a warm body or a placeholder for your court clerk is not really going to do. You're going to have to find somebody who really wants and really loves the idea and doesn't mind the paperwork and the work. And you know that court clerk's eventually going to have a secretary to assist, deputy court clerks to watch over and supervise and begin to really work on and make your court processes really hum along. So so I see a question over in the chat that says, what is the proper order for the clerk, justice, and jury foreman to autograph a grand jury ruling? Well, of course, the jury makes that grand jury ruling. They send that ruling to the justice. And when they seal that, when they sign that, when the jury foreman signs that, puts his thumbprint on it, that's his seal. And then it moves on to the justice, and the justice makes sure that everything was considered within that. Then the justice takes and will affirm that ruling, and then he may have an order that he has to put in, or additional, you know, whatever that is. So additional investigation, maybe it's an indictment that gets handed down. He's going to autograph his name to it, and then he's going to put his seal on it. And that is his justice's seal. And then it goes to the court clerk, and the court clerk does the final filing of that document. From there, if it is a presentment, then it goes to the county sheriff, and the county sheriff takes it out and serves it. Okay, so that's kind of the order of how it flows from the jury to the justice to the court clerk. Remember, the court clerk doesn't make any decisions, and really, neither does the justice. It's all up to the jury. But they're both there to watch over and make sure that justice is served, that the process has been followed, that it has the force of true law, and that it meets the process of the court. Okay, so that's how that actually works through our court system. Okay, all right, I'll take that down. All right. So any other questions on court clerk that we have? If not, we'll move on to the marshal at arms. So I'm going to go back just for a second on court clerk, though, before we move on. So you're going to have a state court clerk, and you're going to have county court clerks. Obviously, the higher jurisdiction is county. But all court clerks, whether that's at the state level or with the county level, they must be publicly elected. It is a public position, and they must be elected by all the people, whether that's on the county or at the state level. And so your court clerk needs to have he's going to have a background check. He's in charge of a lot of assets, and he's going to be thoroughly vetted and then publicly elected. Okay, whether that's the county or the state. So, good question. So, with no sheriff at the state level, who would serve the presentment after a grand jury ruling? So, that would work in a couple ways. First of all, that could be a marshal on your state that could go and serve that. It could be served down to a county sheriff of which that man or woman is on the county, and the county sheriff would then have an obligation to make the presentment. And if you've got a marshal on your state, or a state ranger or trooper through your marshal at arms office, then they would go through that county and transport them to wherever they need to go, whether wherever that might be in terms of from the state level back to another county possibly. Okay, so those are kind of things we'll have to work out as we go along, and we finally get into some physical services on our state and physical buildings and things. So so that's basically how that would work. Now, so let's see here. So Leanne has 3 copies of documents. Who does the court clerk give the original to, or does the court keep the original? So the court is going to keep those originals. And then when the copies go out, everyone gets copies. The court has to retain those wet ink signatures. Those are important within documents and filings. And that essentially, as we know, when you put a wet ink signature on something, that is your contract. That finishes your contracting or your document. So the original is going to be kept by the court clerk, and then placed in a physical file, and then electronic versions are put into IT for public viewing, and then the court clerk will give copies to the claimant and the accused. So so that's kind of how that, I believe, should work. Okay. When documents and evidence is shared with the jurors, what are the acceptable means of communication to get the information out to the jurors? So when the documents and evidence is shared with the jurors, it's shared with all jurors, Carol. So they're all going to get a copy of whatever that is. And they're going to have time to review that. And when they go back to deliberate a case, they're each going to have their own packet to look over in terms of all the information and the documents. And so, and then whatever they do within their jury, whatever their discussion, their debate, and their decision is, that comes out through the court, through their jury foreman. And the jury foreman, when they're seated back into the court, has any questions, has any requests, or they bring the verdict forward. That jury foreman brings the verdict forward. So they would basically let the bondsman or court clerk know when they're ready to come out and reconvene in the court, and the court is reconvened then, and the jury foreman speaks for the jury. Okay, he's sort of, in lack of a better term, the chairman or the speaker of the jury. And so he comes back out with the jury and goes ahead and speaks whatever that jury information is. All right. When claim against de facto U.S. citizen, is court clerk responsible to inform them of American common law process? Absolutely. Absolutely. They have to have the justice to prepare their own defense. That's part of due process. And so you can't just surprise them. So when you're putting up your court documents, you need to be having some type of a document that you can place that talks about your court process and what your American court, your common law court is really all about, what your living court is all about. And they need a copy of how the court process works, because it's so foreign to them, in the way we do things as opposed to how the de facto does things. You know, the difference is, instead of complaining, we claim. And when we claim, we have evidence, we have witnesses. And they just can't come in and say, you know, oh, you scratched my car and now I have emotional distress, right? They can't do that. They're going to have to show that harm. They're going to have to show that where that scratch was so harmful that there was actually some kind of harm. There's not a lot of emotional distress issues that we're going to deal with in our courts. How do you prove emotional distress? How do you prove that it's anything related to an actual incident or case? Maybe. It's not impossible, but it's going to be highly more unlikely than what you see in the de facto. Remember, our claims are supposed to be claims that are that we can restore in some way or another. There has to be a remedy to go with it. And so making just wild claims to get money is not necessarily going to fly in our courts. Okay, it's not about frivolous claims, and our court systems are set up to prevent frivolous claims from coming in. People have to try to do the hard work before a case will be accepted within our court. Now, I would say woe to anybody who just walks in and starts to complain and whine in our court. You know, they can jump forward to a living court, but if they're not prepared for that, if they don't have the evidence and they come in with a frivolous claim, they could end up being the one that really loses in that situation. And so with your court documents, you need to be developing something that talks about what our courts really do and what types of things they need to be providing to us to be able to properly adjudicate their affairs. Okay. So yeah, you absolutely have to inform them. They have to have the ability to prepare an effective defense. Okay. All right. How to disseminate email, telegram, documents to jurors. So in our courts right now, of course, many things that we send out, we send by email. In a physical setting, and those should be PDF, right? Portable document format. That document format is both lawful and legal in terms of our courts. You don't want somebody to have the ability to necessarily change those documents. So a locked PDF is the best way to do that, where it goes out of the office and out of the court clerk's office. He may have a passcode on it. And then that way, that document cannot be altered. Okay. Telegram, you know, I know a lot of people think Telegram is the be all end all, but it is not secure. It's not encrypted. It's not secure. And so you run great risk of putting those types of documents through Telegram. Okay. You really need to be able to you could put them up on a server and have a private password into a file folder of those documents where they can view them, but they can't download them. So there's several different ways that you need to decide in your court how you're going to secure that, because any little flaw or hiccup in that process can lead to basically a mistrial. And so you have to have the ability to really secure those documents well and make sure that there's no shenanigans that go on with those documents. Okay. All right. Leanne says, when a jury decides accused is innocent, what happens to the silver bonds the claimant puts forth before the court? They receive them back. Right? If basically the record shows they're innocent and it comes back to them. Now, in our courts, if you're making a frivolous claim and you've got somebody who's accused has to put a bond up, and it finds out that you're the one that's really guilty of the frivolous claim, then you have to pay all of the court costs, and you subject yourself to being hauled back into court and then going through trial for a frivolous claim. So the penalties can be very large, because then you're getting into libel and slander, and that's direct harm of someone's reputation, which we hold in great honor in our jurisdiction. In the other jurisdiction, they just kind of blow that off. You know, when was the last time you ever saw a slander case ever come to court? You won't, because they do it all the time and they think it's great fun, especially in the media. Jump first and ask questions later, right? So that gets returned to them, but the court costs then get placed back on the claimant, not the accused. So our courts will have a cost. How do we not? Because the court clerk has many different people he's going to have working for him. And a man is worth his labor. So there are going to be court costs involved in that. There may be court costs involved in sending documents. You know, it's not cheap to send something priority mail or register mail. And our courts should not take up those things. Our people are going to have to pay those costs when they go into court. So maybe there's a fee to file a claim, and then there's a bond to secure the accused in our courts. That's one way of doing it. But that fee to file a claim can be refunded or paid for then by the accused if they're guilty. But the rest of the court costs can also be paid by the accused. But the same thing can be the reverse. If the claimant's found that they put in a frivolous claim, then they can be found for those court costs, and they better be on their guard, because then the accused can come back and take them back into the living court side of things for remedy on their false claims. So false claims are not necessarily criminal, but they are actionable in the living court. Okay. All right. Grand jury action against de facto government for ignoring public laws. Are we required to inform them prior to grand jury, or can we just present the jury's ruling to them with fines? Well, in Road to Ruins, you need to put your regular name up there and tell me who you are before I will answer that question. So I'm going to move on to another question. I'll come back. Put your name in the chat. Okay. All right. Pete, can 1 ounce silver rounds 0.999% be used in place of US silver dollars? Well, originally our silver dollar originated from the Spanish dólar, which was 371 ounces of pure silver, 3.7125 ounces of pure silver. And that's where our dollar gets its name from. So that's going to be, that's going to be kind of decided as we go in, but I would imagine that that would be exchangeable, at least for silver dollar. And we'll be able to take and exchange those rounds for that silver dollar, whatever that value of a silver dollar is. So right now, if you look at the cost of a silver dollar, it's about the same as what a silver round is anyhow. So we're gonna have to see what that process really brings, Pete. But I'm gonna guess that probably that will be able to be used in place of silver dollar. Okay, it has an equivalent. So that will be up to exchange values when we get there. So we'll have to wait and see what that really does. Okay. If I had a crystal ball, I would guess, and I would say probably, but I don't have one. So that's not a definitive answer I can give you. Okay. So, all right. All right, Dave, on Arizona. So I'll go back. Thank you, Dave. Grand jury action against de facto government for ignoring public laws. Are we required to inform them prior to grand jury, or can we present the jury's ruling to them with fines? So your grand jury is there as sort of, it's going to decide whether or not there's criminality. That's its job, is to decide whether there is a point of criminality and move it on to a trial. Now, as far as I know, there can be sealed indictments brought against people. Remember, we're not necessarily going against government, but we go against people, right? So there could be a sealed indictment brought against a man or a woman in our court. Where we go after the government then is in the trial jury, where they actually nullify whatever it is that they did and take it out of state law, take it out of state code and direct it as nullified. And there's nullification orders that can go with that. That might be a separate hearing as well. But so we have to remember that we're having living people in our, we address them head on. Okay. When we put things out in terms of directives or notices, you should be directly noticing not only the office, but the man individually. So when I put things out on Ohio, I always have, say it's the governor, and I put his name in there, his first, middle, and last name, and I put comma, a man who sometimes acts as, and right below that, I put in, then I put in the office underneath it. Okay. So, so it's, John J. Doe, a man who sometimes acts as governor, and then I put in there governor of the state of Ohio. Okay, so I'm addressing both sides. So it is one of those things that you're going to address in both ways, and then that way you have the ability to go back and whatever that pronouncement, code, statute, regulation is, you have the door open to not only charge the man who made the decision to trespass on you, but then you have the ability to go back and nullify whatever it is that they had in their codes to trespass on you with. Okay. So, so a grand jury it can be sealed. but then your actual trial by jury won't be. Okay, it'll be on the man itself, and he'll have a presentment charged to him, and he can show up or he cannot show up. If he doesn't show up, then he's going to be probably visited by a marshal, a trooper, marshal at arms, maybe even a continental marshal, depending on the crime. Okay. All right. So Michael put a good point. Shouldn't the state have to decide whether it accepts bullion as currency? Well, actually, it's the Federation, Michael, that decides what we can use as in payment of our debts. So that will have to come out of a Continental Congress if we can use that interchangeably. So for right now, the dollar is the method that is prescribed within our Constitution, and we have to remember that our state, that our assemblies in their governance fall under the Confederation of States, essentially. And we have to operate, those of us who are on with elected positions have to operate within the Confederation of States. So, and that means we have to adhere to some of the constitutional principles. So that's going to be, I think, one of those issues that we're going to have to decide, be a great issue for our first Continental Congress. Okay. All right, let's see here. So Leanne, is there a difference between arbitration, mediation, and impartial review committee? So she's talking about step 2 of the Ohio living court processes. And as a state court, do we choose to call our step 2? So the first thing is no, there's really no difference. Arbitration, mediation, in that step, the claimant and the accused are essentially coming in, and there's a three-juror panel. Okay. They're watched over by either a magistrate or a justice of the peace. But they are, the three-juror panel listens to both the claimant and to the accused. They review at least some of the precursory information, evidence, witnesses, those types of things. And they're going to make suggestions on how to settle your differences. Each one of them could make a separate, suggestion or remedy, a suggested remedy. And that could go back and forth. But they're not there. There is no judgment by them. They're helping both sides to come to some remedy. That's it. So whether you want to call it arbitration, which is really in Bouvier's 1856 6th edition dictionary, or you want to call it mediation, or you want to call it impartial review committee, that's going to be up to your Jural Assembly as to what you name that phase. But it all means the same. It's the same process. Okay. All right. Where do counselors of law they have at law, but we have counselors of law, not at law, Leanne. So counselors of law fit into this list. So they're not, they're as you see within the officers and officials, counselors of law are not official in any way. Okay. They're there to assist. Eventually, they're going to assist in the litigation process of helping someone understand the court process, put their evidence, their witnesses, those types of things together. They'll help them. They're kind of the guy that sits in the old, if you ever watch an old episode of an old court, they're the guy that sits there and whispers in somebody's ear. Now tell him this. Okay, you got him on the ropes. Now do this. Okay, now here's, make sure you bring up this point. Ooh, I heard something. You want to ask a question about this. They can sit alongside the claimant or the accused in a court. They just can't do it for them. Okay? They have to present themselves in our court. Now, the only other time that a counselor of law would actually present, like we said last week, was if there was either a death involved or someone is so severely incapacitated that they cannot present themselves, disabled. Okay? So that's where a counselor of law would come in, and then essentially they become prosecutor if there's a claimant, or defense attorney if it would be the accused. But only if they're either dead or so severely injured, incapacitated to a point where they can't present themselves. Okay. So lots of little ins and outs and differences between our jurisdiction and theirs. One of the differences between our court clerks and theirs then is the fact that their court clerks can reject your documents, right? And they don't have to have a reason. They can take them back to the judge who goes, no, not doing it. You know, oh, it's one of them, not doing it. But in our court clerks have the duty that if something is presented to them that and it has that merit and it is in the order of our court, then they have to accept it. That's part of their honor. Okay. So I'll put this up. Stare decisis apply in American common law courts. Well, actually, if you've got somebody in your court that's arguing UCC and standing on UCC, that is no part of our court. Those codes, statutes, regulations do not apply to us. And the question is there harm or is there no harm? Right? So Anna says 8% of public law only applies to us. Their Supreme Court and their Supreme Court decisions do not necessarily figure into our courts. We're going to be setting our own decisis as we move through what stands and what does not in our courts. Okay. So not very much. Some American jurisprudence, yes. And especially where it comes down to the line of, within the Bill of Rights and the way court officials or assembly officers act and react. Yes, it does. Okay. But it's a very few and far in between. Okay. So you're not really applying their common law, their stare decisis, except for maybe we take something into account where they're violating travel laws and they've violated us in travel laws. We can bring in that stare decisis from their jurisdiction to prove even their jurisdiction says that it's harm. And that's the way you would use it, essentially, and kind of turn the tables on them. Okay. So Jessica, I'm sorry you don't have your question in all caps, but I'm going to show it anyhow. Is 18 months general time frame to be a counselor of law? No. There are a lot of people out there who can serve as a counselor of law. If you're familiar with common law, if you're there to just help somebody in the process, you can be a counselor. Plain and simple. You don't need formal education, although you should be educating yourself, right? But you don't need to have any real formal education to be a counselor of law. Okay. That's de facto. There's many things, think back. We have to think back into the 17 and 1800s early. Were there law schools? Not really. It's the same thing as, were there medical schools? Not really. It's a passed down knowledge. It's a self-studied, a self-governance issue. And so anyone can be a counselor of law, but also realize that you take on certain, I guess, liabilities in that too. That if you tell somebody something and you're steering them the wrong way, or you're steering them criminally, you could be charged with that, right? So we want to make sure that what we're doing in a way that's going to be helpful, not harmful. Okay. So anybody can counsel. In fact, there's wisdom in many counselors, right? Straight from our biblical text, wisdom in many counselors. So it's not, they can come to your litigation committee, and your litigation committee can all weigh in. Often on Ohio, that's what we do. Is we bring somebody in, and there might be 4 or 5 of us in there listening, working, writing, researching, pulling together those things. So, so that's the wisdom in many counselors. Keep that in mind. Okay. But you do want to do some studies, and you want to be able to advise them well. Okay. All right. All right. I'm going to do last question. Leanne, in court hearing, can any official present, bondsman, marshal at arms, ask questions of a claimant or accused? No, they cannot. The only people that can ask questions are the jurors. Now, the justice might occasionally have a question, but that's a very far and few situation. The jurors are the ones that are tasked to be the prosecutors. The jurors are the ones that are tasked with the adjudication. Everyone else there is just there to serve the due process. Okay? So no, they cannot. The jurors could ask questions of them. They could bring them forward, in their behavior before court or after court, or, in any of the dealings they had with somebody. If they were rancorous, if they were, try to bribe them, if they, but the jurors are the ones that have to ask those questions. The jurors are the ones that are responsible to really ferret through. So our jurors have to be very aware, and they have to learn how to go about investigating. That's going to be part of our jury training that we have to do, is they have to become the investigators in that way. They have to sort through the stuff, right? And I mean stuff in that in a different form, and they're going to wade through it, and they're going to come out with the questions that bring the answers all for a good adjudication. Last thing we want is snap judgments. We want them to be able to sort through those issues and decide those issues very carefully. So, anyhow, Pete, I'm gonna defer your question to the next time, because I know nothing about world common law courts. Anna will have to answer that, and we've been almost a little over an hour. So I'm gonna close the questions there. And I just want to remind everybody again, as we're getting ready to gear up that we are doing the American States Family Reunion in 2025 from September 3rd through the 8th. There's where you can book. And right now, that's not a commitment, okay? It's just to let us know how many hotel rooms, because it is on an island. It's a busy weekend, and we're going to need to try to set aside enough rooms to accommodate. So right now we have a little over 104 people who've already signed up that are interested in coming. And so if you're interested, we'll be getting the information out and the costings and things out sometime March to April. The island doesn't really open up from the winter. Right now it's still iced in and snowed in. So it really doesn't open up from the winter until late April and early May. So, but we need to know, have a count on rooms if you're thinking about coming, or if you are coming. So please get your book, go ahead and get your booking in, and realize that that's also the week of Labor Day weekend is the weekend before. So it makes for a great week, a good vacation. And, we are planning some seminars. We're looking for presenters to present little seminars. It'd be great to have, kind of a court and jury roundtable led on the island. And, we're gonna mix that up with lots of learning, a little history, and a little sightseeing, and a lot of relationship building. So we hope that you consider. Michelle Ford and I have been working. We worked on this last year for Massachusetts. We're working on it this year at the International Peace Memorial. And next year in 2026, we're going to be working on having something close to, but not in Philadelphia for the 250th anniversary. So it's something we hope to do every year, and to be able to keep education and relationships going across this wonderful America that we have. Okay. And then, as always, Anna also is requesting donations. So if you've got the ability to send Anna a donation, she does do PayPal as well, Cash App, through her Cash App at $ Anna Rise, REIZE, or you can send it to her physical post office box. And that's Post Office Box 520994, Big Lake, Alaska, 99652. Okay. All right. Well, thank you, everybody. I really appreciate you hanging in. I hope you found today really helpful, and I hope to see you all. And hopefully we may have a time or a date change coming. And Anna is finding it very difficult to work the schedule. So if you see that the date and the time changes, realize that we may be working on that as early as next week to get the date and the time change. We may move it to Wednesday or Thursday just to give Anna a little bit of a break. Okay. So, so thank you very much, everyone. Wonderful questions. Appreciate you being here, and we'll see you next week.